National Assembly Speaker Justin Muturi will, in 3 weeks, make a determination on the fate of 7 constitutional amendment bills that are pending in the House, following the Court of Appeal judgment on the Building Bridges initiative. Former Majority Leader Aden Duale, rising on a point of order, asked the Speaker to rule if the proposed amendments would affect the Constitution's basic structure, rendering them a nullity. As our very own Francis Gachuri reports, MPs had an opportunity to express their views on the appellate judge's verdict that affirmed the High Court judgment stopping the BBI reggae.
The Court of Appeal judgment on BBI was the subject of discussion during the special sitting of the National Assembly. Garissa Township lawmaker Aden Duale seeking Speaker Justin Muturi's direction on the fate of 7 constitutional amendment bills that are at various stages of legislation in the August House. 3 of the 7 bills are sponsored by the Constitution Implementation Oversight Committee and seek to, among other things, allow the President to nominate cabinet ministers from among members of Parliament and allow the losing presidential candidate and his or her running mate to be nominated to Parliament. There are also bills by Florence Mutua and Gladys Sholei seeking to deal with the elusive gender parity law.
It's just the place of those bills relative to that judgment, and also whether the House should continue and the committees should continue considering those bills.
According to Duale, some of the proposed amendments touch on the 2010 Constitution's basic structure doctrine that formed the bulk of reasons why the Court of Appeal in a majority verdict last month stopped the BBI reggae.
So, Mr. Speaker, so that we don't take this House into a limbo and do a lot of stuff that will not see the light of day. Because, Mr. Speaker, we spent resources, time and energy on this animal called BBI. And today we are back to square zero. We don't want the same shenanigans and the same issues to be taken through this House.
The lawmakers differing on the appellate judge's decision.
It's made it now totally impossible, even for Parliament, to actually touch any of the matters in the Constitution. My worry is that this could be extended even on some of the laws that we are making, because they'll be told that this law touches on a certain right that is tied to something in the Constitution that touches the basic structure.
It is not the judiciary. It is a 2010 Constitution that is protecting and fighting for itself. The judges are only re-emphasizing that Kenyans elected a constitution where we sought to have the independence of the judiciary. Kenyans elected to have an independent legislature. And Kenyans elected that at no time, Honorable Speaker, should we introduce an ombudsman that will interfere with the independence of the judiciary.
We don't want executive dictatorship. We don't want a president who thinks he's a god. We don't want parliamentary dictatorship where, Mr. Speaker, you would appear like the god of this country. We equally don't want judicial dictatorship where judiciary thinks they are god. Any dictatorship, Mr. Speaker, is not good for this country.
But we cannot say, for example, that the courts are wrong in saying that there are some issues in the Constitution are so deeply entrenched that you cannot leave it to one individual. Because, Mr. Speaker, a popular initiative can be promoted by even a single individual. Mr. Speaker, you can imagine if David Ochieng would sit down and say that I'm proposing something to say that from the next elections or from the next Parliament will have 600 members of Parliament, and you therein decide that Nairobi will now have 100 constituencies. Which tools do you have as an individual?
And I think when the judiciary goes against their powers, there are people who want us to walk stealthily around them like they are sacrosanct, they are God. The only person I do not challenge is God. When I agree with the judiciary, I speak very clearly because they are not God. Even when I disagreed with the president, I say very clearly, because it's not God.
So when you talk of eternal crosses, it's like we give ourselves crosses that we can no longer touch. We will all die with the way they are written. I don't remember that kind of a discussion, where we give ourselves articles in the Constitution that we cannot amend. I know, and I believe, and I know that is the discussion we had, that it is the amending of
articles that is different. Some will require referendum, others will not require referendum. Others will have to get, you can amend them through popular initiative. So all these channels were opened in our constitution.
Former Chief Justice David Maraga's advice to President Uhuru Kenyatta to dissolve Parliament for failing to enact the gender parity legislation, reigniting debate in the House.
Article 27 is in the Bill of Rights. How then were we? How can then the same judiciary claim that Parliament has failed without explaining what it is we were supposed to have done? Is it Parliament responsible for the electoral system? If you look at the provisions of Article 81, the electoral system shall ensure. That is not Parliament. Parliament is not the electoral system.
Attorney General Paul Kihara Kariuki has indicated his intention to move to the Supreme Court to contest the Court of Appeal decision, a move that would set the stage for yet another legal showdown at the highest court in the land, headed by Chief Justice Martha Koome, months before the general election. Francis Gachuri, Citizen TV.